So we reviewed the federal cases against Illinois' gun ban. April 12th is an open argument for that in the Southern District Federal Courts in East St. Louis. And the state's got until Thursday to reply to the motions for preliminary injunction against the ban. What's going on in state-level courts? Well, there's some movement there where last week on Thursday, the Illinois Supreme Court denied Tom DeVore's motion to consolidate the 4 cases. He's got 3, 2 in Effingham County, 1 in White County. He wanted to consolidate those with the Macon County case from State Representative Dan Calkins. So I talked with Attorney DeVore on Friday to get his reaction to the Illinois Supreme Court not combining those cases. And here's some of the initial reaction he had, especially after raising those concerns that he thinks that the Macon County case is not ready for prime time. Here's Tom DeVore.
Well, we're going to proceed and continue with our discovery that we're doing, and we'll keep doing that out of Effingham County, and we'll move forward the way that the case should move forward, and then we'll see what happens.
And I asked Tom if he still has those concerns that the Macon County case is not, ripe enough with the amount of evidence that DeVore's trying to get when he's subpoenaing a whole host of individuals, from legislators to even associations like the Illinois Sheriff's Association or maybe the Illinois Chiefs of Police Association. So here's Tom DeVore talking about his concerns.
There's nothing good to come out of the Macon County case for the people of Illinois. The complaint itself is the complete plagiarism of all of the arguments that we've made in our case. And so now you have Dan Calkins, who wants to hurry up and rush to the Supreme Court without any original thoughts whatsoever. It's all the arguments out of my client's cases that they're wanting to rush and try to get there first. So there's nothing new or nothing unique or no original ideas there to be brought to the Supreme Court in such a rapid basis. And while it's still possible to win that argument at the Supreme Court in such a rushed basis, it exposes the legal issues, to uncertainties that don't have to be exposed if you just took a little time and further developed all of the issues that could eventually arise. So there's only risk that can be obtained from going so fast, and there's nothing beneficial or nothing that could help by doing it, but we'll address it the way that we have to address it. Yeah, whether it would prejudice our client's case in order to disallow them from being able to present the full issues, I don't know yet. I'll have to wait and see what happens. I can just tell you, Greg, that there's not a lawyer in the state that you could call and talk to that would make any sense out of what Calkins is doing. It makes no sense at all. So, and just be clear, there's still a chance that that case could go to the Supreme Court on an expedited basis, and that, the plaintiff in that case could be successful. It's not impossible, but again, there's a risk that doesn't need to be taken there that's being taken. And that's really the big issue that people should be concerned about is there's no unique arguments being made there. It's the arguments that were developed in all of our cases. And so they're taking nothing new. They're just, again, and I'm using this word very colloquially, so I'm not accusing anybody of crime, but they stole the legal arguments out of our cases, and now they want to run and try to be the first to the finish line. And it's a dangerous thing to do, and it's unfortunate, but we'll just address it as we address it. I can't stop it.
So again, that's Tom DeVore, attorney for the cases out of 2 of them in Effingham County, 1 of them in White County, ultimately saying that he still feels that the case brought by State Representative Dan Calkins is not ready. He says that they're not going to have the ammunition in their chamber, so to speak, to go to the Supreme Court and have that evidence about the training aspect, for instance. But DeVore, his case does have a variety of different motions for subpoenas that he wants to issue to not just state legislators who supported this, not just the governor's office, but also various associations. And one in particular has filed a motion to quash a subpoena, and that's coming from the Illinois Sheriff's Association, so they don't feel like they have to turn over any information on this. So there's an interesting dynamic there when it comes to how law enforcement may or may not have negotiated on this. Like, if you recall, the Illinois chiefs of police, they did publicly post that they opposed Bob Morgan's bill as written. And that was when it just said, you know, you could only have the gun while you're at work. It had nothing to do with transferring the gun back and forth. So what kind of discussions happened behind the scenes there? That's something that Tom DeVore is trying to get after, that he says Dan Calkins' case is not getting after. But DeVore's motion to consolidate the 4 state-level cases where there are temporary restraining orders in place blocking the state from enforcing the measure on thousands of individuals, that's a problem for the Calkins case. I talked with Jerry Stocks, and he says that he's fighting to ensure that there is relief as broad as possible for all of Illinois, rather than just being for a select few thousand who signed on to lawsuits that were brought by attorney DeVore. So coming up next, we'll hear from Jerry Stocks in response. But real quick, DeVore says he's ready to amend his complaints and possibly let others sign on to it.
Yes, there's a couple of things. And again, that's the initial purpose of amending the complaint, Greg, is the issue of the single subject rule that you're familiar with. I'm going to go ahead and pull that out because I understand the appellate court's rationale on that. We're going to come and we're going to bring it back to 3 readings, the procedural issue of 3 readings, and to the equal protection. We're going to narrow it down to the 2 main issues that I think the Supreme Court should really hone in on. And so we're going to amend it for that. And in the meantime, since we're going to amend anyway to, reduce it to those narrow arguments, we're going to give people the chance to join in if they want to, because I can do it all at the same time and it doesn't slow anything down.
So more people will be able to sign on to DeVore's cases when he amends that. We'll see just how far that goes. But next, I'll share with you the conversation I had with Jerry Stocks, the attorney for Dan Calkins in the Macon County. I hope everybody understands what I see my role in all of this is just to give you kind of a play-by-play of where we're at when it comes to how these cases are playing out to challenge the state's gun ban and registry, be it in state-level court or federal courts. And I think it's important that you hear all the sides on the side of those challenging it, because there seems to be different approaches, different takes, different ways of going about this. And that's become clear in the state-level cases, where we just heard from Tom DeVore. He's got 3 cases, thousands of people who've signed up as plaintiffs. They have temporary restraining orders in place. He's looking at possibly opening it up for even more plaintiffs to sign on. But in the Macon County case from State Representative Dan Calkins, you've got attorney Jerry Stocks, who's taking a different approach. And while he has a temporary restraining order in place for Calkins and a pawn shop and a gun dealer and a list of Macon County gun rights groups of sorts, individuals in a loose association, he's got that case, but he does not want to delay it. He wants to get it advanced further. And I asked him to respond to DeVore, who still is publicly saying that Stocks is going too fast with his case. And here's Stocks' response.
Your question is loaded with a false premise that what DeVore articulates is valid. We submit that what DeVore is seeking is not material to the resolution of the issues that could be resolved. Why would we not wait 4 or 5 months and leave in peril and jeopardy 2 classes of people? Those that are under a temporary restraining order, which only restrains enforcement during the term of the temporary order, does not restrain it on for actions before or after. A judgment of invalidity in the circuit court renders the statute void as if it never existed. That is a far broader and deeper protection, not only of the people that are claiming a cloak of protection under a temporary restraining order that I tell you is a cloak with many holes. And we have, 2.2 million FOID holders in the state of Illinois. and at most a few thousand that are protected. So there's a person shouldn't be protected from an unconstitutional law only because they have paid Mr. DeVore $200. The objective is to assure the maximum amount of citizens' protection while the constitutional question works out.
So again, that's Jerry Stocks making clear that his goal is to get the maximum amount of Second Amendment protections for the entire state instead of just people who pay $200 to sign up as plaintiffs to a lawsuit. So interesting to see how that all plays out. Stocks will have a hearing later on this week in Macon County.
From the Fly SPI studio.